Good afternoon and welcome to this LexisNexis webinar on capital allowances. This session is a follow-up to John and Anne's talk earlier this year on capital allowances, which is still available on the LexisNexis website.
But I think what this slide illustrates is critically important after April 2014 that buyers and sellers think about what they're going to do in the purchase contract about capital allowances. If they don't sort it in the contract, this is a very substantial PI risk for property lawyers and for any tax advisors who are brought in to give specific advice on a transaction. And based on what people are currently doing, probably less than half of people buying, selling buildings get the contract correct in terms of capital allowances. So I think my strongest message from this webinar is if you've got any clients who are buying, selling buildings close or after May 2014, they seriously need to get their house in order.
The challenge is, I think, and you're absolutely right, is to change established conventions, because the rule used to be if you were advising somebody who's buying a building, if they hadn't made a claim, a silent contract would be best. Those rules, that old rule has gone out the window now, because if you want to be able to make a claim for allowances, you will need a paper trail in place.
Absolutely.
And it's important as well, of course, that not just Mr. Abramovich, who won't get any allowances, but any future owner.
Absolutely, any future owner. Now, if in this example Mr. Putin had not been in the charge to tax, so it'd been in a pension fund or property developer, then the current rules would apply. So there would be nothing to, because in that case Putin would not be able to pool or to claim and wouldn't be able to enter into a tax election. So in that context, if the seller's not in the charge to tax, there's no real change in this particular scenario.
I'm conscious because of time, but briefly, if the buyer, if Abramovich was buying here because Putin had gone into receivership, and touching on one of the questions that was raised earlier, what's the impact there of buying from a receiver where there, from experience, and again we were chatting about this earlier, there is little data available?
It's very difficult, particularly for smaller value transactions. If the value is less than 10 million, receivers can be very uncooperative in terms of tax. They will not have very often tax computations. They'll not have records available. I think one of the things that you can do as a minimum is to get some wording in the sale contract that the receiver post completion within an agreed time frame will do best endeavours to get access to historic tax computations, tax returns. Whether they will agree to that is difficult. If it's a larger value property, then there must have been some accountants, tax advisors available to the company before they went into receivership. You've got to do quite a bit of due diligence, but the legislation just fails in this area. Whether in the context of a receivership you could go to a tribunal, what do you think, Anne?
I think you can certainly make an application. The difficulty is going to be providing evidence satisfactory to the tribunal as to why they should find in your, agree that whatever you want is the appropriate proportion. I think if you went and said there's no paper trail whatsoever, we can't say what's been claimed in the past and so on, the tribunal might well be quite reluctant to grant anything very much.
Yeah. How about going to the revenue and saying, look,
you should have this information.
You should have this information.
The slight problem with that is data protection, because you're effectively asking the revenue for details of somebody else's tax affairs. And the revenue is not supposed to disclose that. I mean, if you can get the agreement of the receiver, but even there, there's a slight question as to actually whether the receiver could, whether there's still a data protection issue, given that you're not actually asking on the taxpayer themselves, you're actually asking from the, if you can get agreement back through, then that might work in that sort of context. To be honest, you're probably better off trying to negotiate a smaller payment for the building.
Purchase.
Just to be absolutely sort of bluntly commercial about it. If you don't think you're going to get capital allowances, pay less.